Okay, thank you for joining again. We are continuing with our series of law of persons. So this time we are dealing with intoxication from drugs and or alcohol as a factor affecting status. Okay. So this learning unit deals how intoxication from alcohol or drugs can affect a person's legal status or capacity. Okay. Um, so you must at least understand the meaning of intoxication, how intoxication affects capacity, and when an intoxicated person may be placed under curatorship. Okay. We'll also explain um, how you can apply intoxication into contracts, litigation, office holding, intellectual liability, and criminal liability. Okay. The main idea is that the law normally assumes that an adult person can understand what they're doing. But if a person is so intoxicated by alcohol or drugs that they cannot understand the nature and the consequences of their actions, the law may say that the person lacked capacity at that particular moment. So this is similar to a mental illness, but the difference is that intoxication is often temporary and it may be self-induced. Okay. So excuse me, in simple terms, the law asks, was the person merely drunk or were they so intoxicated that they did not understand what they were doing? This distinction is very important. A person who had 2 glasses of wine and signed a contract is not automatically protected by the law. But a person who was so drunk or drugged that they didn't know what they were signing may lack capacity, right? For example, imagine Tabo goes to a party, drinks heavily, and later signs a contract selling his car for 500 bucks. The next morning, he says, I was drunk, so the contract must be invalid. You know, the law will not automatically accept that. The question is not simply whether Tabo was drunk. The question is whether he was so intoxicated that he could not understand that he was selling his car and that the buyer would be entitled to it, right? So intoxication affects capacity only when it reaches a serious level. The person must be unable to understand the nature and the consequences of the act, right? So intoxication means that a person's mental or physical functioning is impaired by alcohol, drug, or another substance, right? So in law, intoxication matters when it affects the person's ability to reason, to understand, to intend, or control their conduct. Um, so for especially first years, I would assume that mostly first years would watch this, you know. But I mean, for everyone, but for beginners in law, intoxication is not a free pass. The law doesn't say you were drunk, therefore nothing counts. The law says, were you so intoxicated that your mind could not properly understand the legal act? You know, so, for example, if Naledi buys shoes online after drinking lots and lots of alcohol and she understands that she's buying shoes, then the contract is valid. But if Naledi is so intoxicated that she thinks she is playing a game and does not understand that she is spending real money, the contract may be challenged, right? The level of intoxication is therefore the key issue. So, um, let's talk a little bit about capacity, intoxication and capacity to act. So capacity to act means the ability to perform a valid juristic act, right? You already know that. A juristic act is an action that is intended to create legal consequences, such as concluding a contract, donating to property, selling a car, making a will, accepting a purchase offer, or settling a legal dispute, right? So if a person is intoxicated but still understands what they're doing, they have capacity. If the person is so severe, if the intoxication is so severe that the person cannot understand the nature and the consequences of the act, then they lack capacity. So, for example, if Sipho drinks beer at a braai and then sells his old phone to a friend for $10, right? That contract would probably be valid if he understood what he was doing. But if Sipho was so intoxicated that he did not recognize the phone, did not understand money, and did not realize he was transferring ownership, the contract may be void, right? So the legal focus is not morality. The court is not asking whether Sipho behaved responsibly. The court is asking whether Sipho had legal capacity at the time of the act, right? This brings us to the whole point of intoxication in contracts. So in contract law, both parties must have the capacity to contract. So if intoxication destroys capacity, the contract may be void. For those who don't know, void means that the law treats the contract as if it never validly came into existence, right? This will only happen in serious cases. The intoxicated person must show that they lacked understanding. It's not enough to say, I regret the contract because I was drunk. Regret is not the same as incapacity. So imagine someone goes out, they drink alcohol, obviously, and later buys an expensive watch for about 50,000 grand, right? 50,000 rand. And the next day they feel embarrassed about the amount of money that they spent and they want to cancel the purchase, right? If they knew they were buying the watch, they knew the price and they understood that they had to pay, the contract stands. But if they were so intoxicated that they thought that the watch was for free, or they thought they were signing a dummy document, there may be no valid consent, right? Because the law protects genuine incapacity, not bad bargains. Okay, so voluntary intoxication. Voluntary intoxication means the person the person chose to drink alcohol or take drugs or whatever substance, right? This matters because the law is usually stricter when a person voluntarily causes their own impaired state. Okay. In civil law, voluntary intoxication may still affect capacity if the person genuinely could not understand the act. But the courts are careful because people should not easily escape legal consequence by relying on intoxication they caused themselves. For example, if a person deliberately gets drunk and then signs a business contract, they cannot simply say, I choose to drink, so I am not bound. They must prove that intoxication was so extreme that the capacity was destroyed, right? And then now let's go to involuntary intoxication. Involuntary intoxication happens where a person did not freely choose to become intoxicated. For example, someone's drink is spiked or they're given medication without being properly warned of its effects, right? So in this situation, the law may be more sympathetic because the person did not voluntarily cause their impaired state. If the intoxication destroyed their ability to understand their actions, their legal act may be invalid, right? Think of this. If Lerato's drink is spiked at a party and she signs a document giving away her laptop, the law is more likely to protect her if she lacked understanding. She did not voluntarily place herself in that state. right? Okay. Now let's talk about intoxication and litigation, right? Capacity to litigate means the ability to sue or be sued in court. Intoxication is usually temporary, so it does not normally remove a person's general capacity to litigate permanently. However, if a person is intoxicated at the time they are supposed to give instructions, testify, or make important litigation decisions, their ability to participate at that time may be affected. The court may delay the matter or require proper representation if the person cannot understand what's going on. For example, if a person arrives in court extremely intoxicated and cannot understand the proceedings, the court will not treat them as properly participating, because once they are sober, they can usually continue with the case. This is different from severe mental illness where a curator ad litem may be needed for a longer period. Okay? Just remember that. And then now we talk about intoxication and holding office. Sometimes offices require judgment, responsibility, and trust. So intoxication may affect a person's ability to hold office if it shows that they cannot properly perform their duties of that office, right? For example, a person who is repeatedly intoxicated while acting as a company director may fail in their duties, you know. A trustee or a director, they must act responsible in the interest of others. So if intoxication prevents them from doing that, there may be legal consequences, right? But again, intoxication does not automatically remove a person from office. The issue is whether intoxication affects their ability to perform their role properly. It does not automatically remove them from office. Okay. Um, Now let's talk about intoxication and delictual delictual liability. Yes, here. Intoxication and delictual liability. So intoxication concerns sorry, delictual liability concerns civil wrongs, right? Such as damaging property or injuring another person. To be liable in delict, a person usually needs fault, meaning intention or negligence, right? So intoxication may affect whether a person had the intention or negligence. So if the person was so intoxicated that they could not understand what they were doing, it may be difficult to prove intention. However, the law may still find negligence if a reasonable person would not have placed themselves in that situation. For example, if a person drinks heavily, gets into a car and crashes into someone's wall, they cannot easily escape liability by saying I was drunk. In fact, choosing to drive while intoxicated may itself be negligent. So the law may say you may not have intended to crash, but you acted unreasonable by driving while you were intoxicated. You know, a different example, if someone's drink was spiked and they accidentally caused harm while completely unaware of reality, the law may be more sympathetic because intoxication was not voluntary. So in delict, always ask, was there fault? Did the person act intentionally or negligently? Was the intoxication voluntary or involuntary, right? Now let's talk about intoxication and criminal liability. Don't confuse criminal liability and delictual liability. So criminal law is much stricter because intoxication often appears in criminal cases. Okay. A person may argue that they were too intoxicated to form intention or understand wrongfulness. The idea is that criminal liability requires more than physical conduct. the person must have criminal capacity and fault. So if intoxication is so extreme that the person cannot understand what they are doing or cannot appreciate wrongfulness, their criminal liability may be affected. South African law is very cautious because society cannot allow people to drink, commit crimes, and then easily escape punishment. Voluntary intoxication is treated carefully. So, for the purposes of beginners, right, intoxication may affect criminal liability, but it is not automatically a defense. The court will consider how intoxicated the person was. Sorry, just a sip of water there. Whether intoxication was voluntary and whether they could still understand and control their actions. For example, if someone drinks alcohol, right, and intentionally accuse another person, they will usually still be liable. But if someone was so intoxicated that they had no understanding of what they were doing, the legal position may change. So when it comes to criminal liability, the facts matter. Okay. Let's deal with a very important case, the Shretin case, right? State versus Shretin, a 1981 case, right? So um, this is a leading, a leading case in intoxication. It's a very important case. So in State versus Shretin, the accused had consumed alcohol and drove a vehicle into people at a party. The legal issue was whether intoxication could affect criminal liability, especially intention and criminal capacity, right? So the court accepted that intoxication may, in certain circumstances, exclude criminal liability if it prevents the accused from having the necessary intention or capacity. In simple terms, if a person is so drunk that they cannot form intention, they may not be guilty of a crime requiring intention. But this case caused public concern because it seemed to allow drunk people to escape liability too easily. People worried that an accused could say, I was drunk, so I'm not guilty. To deal with this concern, Parliament later enacted legislation to address voluntary intoxication. The law now makes it possible to hold a person criminally liable in certain cases where they voluntarily became intoxicated and then committed a prohibited conduct, even if intoxication affected their ordinary criminal capacity. Right? The important lesson is not to go deep into criminal law. The basic point is this: intoxication can affect capacity, but voluntary intoxication is treated strictly because people are expected to take responsibility for getting themselves into that condition, right? So another case is the case of State versus Johnson, right? This is a 1969 case. So this is another case that is often mentioned, in intoxication discussions in S versus Johnson. This case dealt with the effect of intoxication on criminal responsibility. The older approach was generally strict. Voluntary drunkenness was usually not a full excuse, although it could sometimes affect whether the accused had a specific intention before getting drunk. So the importance of older cases like the Johnson case is that they show how the law struggled with finding a balance. On the one hand, criminal liability requires blameworthiness. On the other hand, society does not want people to avoid responsibility simply because they voluntarily drank alcohol, right? So the development from the older cases to Shretin shows the legal tension, should intoxication excuse the person because they lacked intention, or should the law punish them because they were because they chose, to become intoxicated. South African law now tries to balance both concerns. Okay. So in this unit as well, we expected to cover, a curatorship of an intoxicated person. So this applies especially where intoxication is not um is not a once off a once off event, but a continuous or a habitual problem. So if a person is repeatedly intoxicated to the point they cannot manage their own affairs, the court may appoint a curator to protect them and their estate. For example, a person has serious alcohol dependency and constantly sells household goods, withdraws all their money, signs harmful contracts, and cannot pay rent or buy food. Their family may approach the court for protection. So the court may appoint a curator bonus to manage the person's financial affairs, right? So this is not done because the law wants to shame the person. It is done to protect their property and prevent exploitation. So the court will not appoint a curator lightly because curatorship limits a person's freedom and autonomy. So, with everything that we have covered, I think it's important that we deal with the difference between mental illness and intoxication, so that you can understand the distinction between the two. So, mental illness and intoxication are similar because both affect capacity, right? But they are not the same. Mental illness may be ongoing or long term, right? Intoxication is usually temporary. Mental illness is often not voluntarily caused, right? Intoxication may be voluntary, especially where a person chooses to drink alcohol or to take drugs. Because of this, the law is often stricter with intoxication. For example, a person with severe dementia who signs a contract may be treated differently from a person who voluntarily drank too much at a party and signed a contract. Both may lack understanding, but the law will carefully examine the facts and the cause of the incapacity, right? So maybe before I end this off, I can generally, show you how to answer, problem question regarding intoxication. So when answering a problem question, use this structure, right? First, you must identify the legal issue. Did intoxication affect the person's capacity? Secondly, you must state the rule. The rule: intoxication affects capacity only if it prevents the person from understanding the nature and consequences of the act. And then number three, you must apply the facts. Was the person merely drunk or completely unable to understand? Right? Was intoxication voluntary or involuntary? What act did they perform? Contract, delict, crime, litigation, and lastly, you must just write a very clear conclusion. Okay, so let's say, for example, Kabelo. Although Kabelo was drunk, the facts show that he negotiated the price, signed the agreement, accepted payment. This suggests that he understood the nature and the consequences of the contract. Therefore, the contract is likely valid, right? But if the facts say Kabel was unconscious, incoherent, did not know where he was, and thought the document was a game, then you conclude differently. The contract is likely void because intoxication destroyed his capacity. Okay. So I think let's end it there. And then if you have any questions, you can leave them down below, and you can obviously subscribe, join membership, and follow for more lessons like this. Thank you.